Hello, everyone. I'm Jason Montgomery, a partner in Husch Blackwell's Higher Education Group. Thank you for joining our program today. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the Program Materials folder. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all for housekeeping items. Let's get started with our program. Presenting with me today is Taronda Randall and Christina Miner, my colleagues at Husch Blackwell. Taronda is an attorney in our higher education group. Clients count on her broad background in college athletics and sound legal judgment to address complex and evolving NCAA compliance, legal, and regulatory issues in college athletics. She brings invaluable experience to her private practice, having served in the athletic departments of major public universities and as a postgraduate intern at the National Collegiate Athletic Association National Office. Christina is a senior athletics consultant in our higher education group. Before coming to Husch Blackwell, she attended Marquette University Law School's sports law program, interned with the NCAA, and accepted a position after graduation in compliance for the Big Ten Conference. She later joined the compliance offices of Rutgers University and Northwestern University. Now she assists clients with athletics compliance reviews, NCAA infractions, student-athlete relations, Title IX questions, and various hot topics in university athletics, such as NIL rules. Christina loves supporting compliance offices like the ones where she launched her career, and she finds it rewarding to help those in the daily trenches of the university athletics. Thank you for joining us today. We hope that the presentation will be valuable. Okay, enough scripted material. Now we're just going to freestyle for the rest of the time. Happy New Year, everyone. College sports is still in transition. This is a discussion about the evolution or revolution or devolution of college sports currently. Some might say it's just plain messed up, but we'll let you decide after we discuss the relevant topics. We're going to discuss a recap of 2024. There were a significant number of court decisions that resulted in the NCAA having to take action in response. We're going to talk about what's upcoming with the House settlement that is still pending for approval in April, and some recent developments, as all of you are probably aware, with respect to a guidance document provided by the Department of Education, Office of Civil Rights, and a submission to the court by the Department of Justice. We'll then talk about some, of the remaining questions that are out there, including participation of transgender student athletes as a community, and the future of the NCAA. Just real briefly, so I wish I could see everyone for this. So the NCAA lost a lot in court last year. They were the Washington Generals of defendants in court cases. Taronda told me that no one knows who the Washington Generals are. So I'm going to explain. If I have to explain a reference, it's not good.
It is not, but
go
ahead.
They always lost to the Harlem Globetrotters. So they're the Washington Generals of defendants in court cases. And this resulted in them not proactively addressing many of the issues that were facing college sports. I think that the reality here is that time's starting to run out on the ability of the NCAA as a governing body for especially the autonomy for conferences in Division I, and the concept that of a big tent of Division I schools. That includes schools as big as Alabama and as small as Robert Norris. I think the days of this big tent concept are numbered, and we'll talk about the reasons why, and we'll start off by Taronda recapping 2024.
Well, Jason, we received a comment that some people do in fact know who the Washington Generals are. So I stand corrected, some, but not all, I assure you. So what happened in 2024? Jason replaced my choice of images with this. My choice was the monkey that looked somewhat confused as to what had happened, because a lot happened in 2024. So early on, we had the continued conversation regarding property interest in NIL and athletics participation / the right to compete. And that was led in part by like Manhattan College. A student athlete received a preliminary injunction allowing them to compete during their 8th season. That student athlete first enrolled in 2016. They were injured. They were granted a hardship waiver. COVID happened, so they received the COVID waiver. They were injured again and received another hardship waiver. But in 2022-23, they played in 9 games and had some lingering injuries, but the hardship waiver was denied due to lack of sufficient medical documentation to prove that the injuries were in fact season ending. The judge concluded that the student athlete would suffer irreparable harm if a preliminary injunction was not granted, and noted that denial of eligibility could carry a detrimental residual effect on their pro basketball prospects and NIL opportunities. That conversation also involved University of Illinois men's basketball student athlete Terrence Shannon Jr. So now we're in February. We have a preliminary injunction that was granted related to state of Tennessee and others versus the NCAA, prohibiting the NCAA from enforcing their NIL rules as it related to NIL compensation from third parties. In response to that preliminary injunction, in March, the NCAA paused investigations related to NIL activities from third parties. And now we're in April. I'm trying to get through this as quickly as possible, Jason, because I know you have a lot to say. In April, the NCAA adopted legislation to allow immediate eligibility for transfer student athletes, provided they met certain academic requirements. Then in May, the NCAA and the defendant conferences agreed to a settlement of consolidated antitrust cases of House, Hubbard, and Carter. There'll be a lot more about that later. Also in May, a judge entered a ruling related to Ohio and others versus the NCAA. That was another a transfer rule. July, the House settlement terms were filed. September, those terms received preliminary approval. And then in October, a lot of different things happened. We had the elimination of the NLI program, National Letter of Intent, transition of those benefits from the NIL program to NCAA legislation in terms of protections. There was also a change in the infractions world in regards to individual culpability for sports wagering violations. Traditionally, a school is held responsible for the behavior of their staff member at the same level, but there was some recognition that in instances where it was truly individual behavior, there was no institutional lack of oversight, that the people should be held responsible at different levels.
So just want to pause here real quick and talk about a couple of things. First is the antitrust issue that is in Tennessee and related to NIL. And then we'll also talk about the transfer issue. Both of those, what I think is important to understand is that the NCAA as a governing body had collectively with its member institutions agreed to certain rules. And in both of these instances, it wasn't an individual that was making a claim. It was the attorney generals of, in one case, the state of Tennessee and Virginia, in the other case, the state of Ohio and West Virginia. And the reality here is that the NCAA as a governing body that lost the faith of its members, such that those members, when faced with in the Tennessee case, a possible infractions matter, instead of resolving it internally, sought some assistance, I think it's fair to say, through their attorney general, and it was effective. Tennessee doesn't have a NIL case. Likewise, when a student athlete was not eligible to compete, West Virginia, whether they or through emissaries or through other attorneys, used that as an opportunity to challenge the specific rule. And the rule there was essentially a one-time transfer rule. So way back in the olden days, when I used to watch the Washington Generals and I was on the NCAA staff, there was a one-time transfer exception for all sports except for baseball, basketball, football, and men's ice hockey. And then the NCAA said, we can't keep doing this. We have a bunch of waivers in all these sports. So we're going to eliminate the one-time, or we're going to allow a one-time transfer for all sports. Makes sense. And they did that. And then this is the next step of that is, should you even have any restriction on transferring of students? And again, the reason that this is decided by a court and not independently by the NCAA membership is because there was no conversation, there was no meeting of the minds with the membership, there was denial, and that denial had some, I think it's fair to say, financial implications, because many of these athletes are now getting paid directly by third parties at this point, and soon to be directly, to compete for their schools. And that financial implication of what was being paid was significant both to the individual and to the school or the school's boosters themselves. So all of this is a culmination of what has been developing since the 2021, since the adoption of NIL.
And I think we saw some themes that came to light with the Ohio and others versus NCAA that Jason, I'm sure we'll talk about throughout. Really came down to the restraint of the labor market of D1 talent, as well as restraining student athletes from moving freely to improve their economic opportunity, their personal growth, and overall well-being. Continuing on with October 2024, we had the reduction of the transfer portal window for basketball and football. I think as it relates to the transfer portal in the window, we all can agree that there were some unintended consequences. See Marshall not having enough athletes to compete during their bowl game and having to sit it out. So wrapping up the 2024, we have Diego Pavia. Particularly proud of this use of the Oprah meme. I'm sure we can all understand why it is used in reference to eligibility, it seems, at this point.
Why is that?
This is not one that you have to actually explain, like the Washington Generals. And I don't want to insult our attendees by actually explaining, because everyone gets it in terms of where we are, or what it seems like where we are when it comes to eligibility. So Diego Pavia challenged the NCAA rule that counted his competition as a JUCO student athlete against his seasons of competition. And he argued that the rule was an undue restraint of the labor market for college football athletes in violation of the Sherman Act. And for the preliminary injunction that he sought, there was a balancing test. So when you're dealing with a preliminary injunction, you have to have likelihood of success on the merits. The plaintiff has to suffer irreparable harm. There has to be a balance of equities, and the impact of the injunction on the public interest is also considered. Now, the NCAA argued from the start that the Sherman Act wouldn't apply because the rules at issue were not commercial in nature, if you will. But the court actually agreed with Pavia's assertion that when the NCAA changed the rules related to NIL compensation and lifted that restriction, the rules regulating who could play became commercial in nature. And for Sherman Act, we use the rule of reason analysis, which is kind of a three-step process that we'll walk through really quickly. So the plaintiff has to show that the rule of restriction has an anti-competitive effect. In this instance, Pavia asserted that the labor market is distorted. Student athletes are pushed to attend NCAA member institutions due to eligibility rules so they can enjoy, a full NCAA Division I career, even if junior colleges may otherwise be a better option for them. The effects on the labor market, and this is a direct quote, the effects on the labor market also cause downstream effects for consumers of collegiate athletics because the restriction on the eligibility of former junior college student athletes to compete at the D1 level harms the competitiveness of the teams by limiting the number of years these players can compete at the D1 level. So after the plaintiff shows that the rule that's being challenged has an anti-competitive effect, the burden then shifts to the defendant to show that there's a pro-competitive rationale for the restriction. The NCAA offered the rationale that the age and experience disparities in preserving the quality of experience for student athletes was the reason or the rationale behind the rule. Court was not persuaded that that was needed for the differentiated athletic product that we know as Division I athletics, and it cited there being a number of reasons that athletes can be older and stronger than those with traditional trajectory. Think about the exceptions related to military service, religious obligations, professional careers in other sports, etc. The court also pointed out that the NCAA had recently made changes to its rules that don't appear to support this stated goal of quote unquote natural and standard degree progression. And that was in reference to the rule allowing unlimited transfers. After that, the burden then shifts back to the plaintiff to show pro-competitive effects can be achieved through less restrictive or less anti-competitive means. And Pavia proposed, and the court found it compelling, that the less restrictive means could include changing the start of an athlete's clock to be triggered when they actually start at an NCAA school and not just any collegiate institution. And for the definition of intercollegiate competition to be specific to NCAA member institutions and not just any 2 or 4 year institution. There were some other things that stood out to me when it came to Pavia. So the NCAA argued that Pavia's delay in seeking injunctive relief weighs against the finding of him actually being able to show that he was indeed suffering irreparable harm. And the court agreed that there had been some recent changes, both in Pavia's personal circumstances, as well as the legal landscape that we're talking about today. So the fact that he did not challenge the eligibility rules until now didn't discount the fact that he would in fact suffer irreparable harm. Finally, continuing on with the analysis needed for a preliminary injunction, the balance of equities and public interest weighed in favor of granting the injunction. The NCAA argued that, that injunctive relief would have a sweeping change that would upend Division I eligibility rules and apply across sports to over 180,000 on Division I student athletes. The court found that to be overstated. They said that the scope of the preliminary injunction was actually narrow and that enjoining the NCAA from enforcing the intercollegiate competition rule would not result in substantial harm to others or to the NCAA. And the public interest itself would be served by promoting fair and free competition in the labor markets. So that, go ahead. I felt it in my spirit that you were about to say something.
Well, before we get to the next slide, just kind of big picture here. Since what we learned in 2024 is since NCAA versus Alston, prior to NCAA versus Alston, the NCAA was the Harlem Globetrotters of these cases related to eligibility. They always won. They never lost. And they've now become the Washington Generals because there's no longer any deference to the rules of collegiate athletics that the NCAA has made when it comes to antitrust analysis, what the NCAA versus Alston court decided. And so as a result of that, these cases are consistently being brought. What that really means is that the NCAA needs to evaluate every rule that provides some limitations on its athletes or come to some other type of resolution. And we'll talk about what the proposed other type of resolution is for the NCAA in this case.
That is supposing that we don't run out of time. So let's keep things going. Jason, I'm going to turn it over to you to explain this next slide because I, like the attendees, have no clue what you meant by this blank slide.
So not to be derogatory towards our former employer, the NCAA. It's been a long time for me and for both of you guys, but I'm not sure exactly what was accomplished, why everyone got together to have an NCAA convention, because the reality is they voted on one thing of substance related to women's basketball and distribution units that everyone agreed to. But with respect to what is going to happen next in college sports, there's nothing that I've seen or heard that came out of this convention. There's no framework, there's no structure, there's no discussion of what rules are there going to be, what rules aren't there going to be. And so it really is frustrating, I think, for the folks that are daily trying to figure this out on campus, and equally frustrating for us who are trying to assist clients with navigating what the rules will be or are or might be. And I'm just going to give one example because it just bothers me so much, I can't help myself. So we still have, the NCAA still has in their manual a bylaw 12, which is related to athletics eligibility and amateurism. They have not revised one sentence in bylaw 12 yet that I'm aware of. There is still a bylaw that says if you use your skill directly or indirectly for pay, you are no longer eligible to compete. I'm just going to make this suggestion, and everyone out there feel free to send an email to your NCAA representative. I'm sure you know who that is. But let's start by deleting that sentence in Division I and then we can move forward with the rest of it. But it is disconcerting that that there hasn't been more discussion about what is next, because we're coming up on April, and after April, there's going to be an entire transition in college athletics. I'll get off my soapbox, sorry.
That's okay. We have another slide where you'll need to be on your soapbox. So speaking of that transition and what's to come, I think that's why you posed this question. So I'll let you explain and impart your wisdom to our attendees regarding this image.
Okay, so I asked Taronda if she knew what kintsugi is. So kintsugi is this.
Can we say that I understood the concept once you explained it? I didn't know the technical term.
It's the Japanese art of repairing what is broken in a more beautiful way with, gold. And as you see, that's the result here. And what I said, well, this is really an analogy of what's going on here. Like, everything is broken and there needs to be some repair. And I'll tell you why I think this is the attempt, at least, is some level of golden repair. And that's by the Autonomy 4 that have kind of taken the lead in the settlement. It's because beginning in 2026, they're about ready to receive $1.3 billion annually from the ESPN for the college football playoff. So they're going to have money to try to fix this system by direct payments to athletes. Pretty much everyone else in college, Division I college sports, doesn't have that same, golden opportunity. But I think if there was ever a time to attempt to distribute additional resources to the athletes, now would be the time when you have access to this additional capital. The other, I think, bigger issue that no one talks about is football, men's basketball, and everyone else. And I think we'll talk about it a little bit with respect to the distribution model that's being used in the House settlement: 75% to football, 15% to men's basketball, 5% to women's basketball, 5% to everyone else. Is that the disparities between the economic impact of television contracts for basketball and men's basketball in particular, and football, are so great that it's almost as though they need to be completely separated from everything else that's going on in intercollegiate athletics. And that simply is not something that the membership or individuals involved in college sports have fully embraced or decided to implement.
Thank you. Well done. So moving on, we're going to switch gears. Jason, do you want to provide some thoughts regarding look ahead, or do we want to turn things over to Christina?
No, I just like the reference here.
That everything's fine.
Yeah. I mean, we all say that sometimes in our office too, when things are going on.
I do, especially working with you. I say everything's fine all the time. So, Christina?
Hey, that's a personal favorite of mine, is everything is on fire, and yes, it's going to be fine. It's all going to be fine. Say it with a smile, and then you'll believe it's true. All right, so with that, we got to talk about House. For the 400 some odd of you that are on this, I know you are sick of hearing about House and talking about House. I get it, I do. But considering this is, setting the foundation for the new Division I model and potentially 2 and 3 at some point, we got to make sure that we are collectively 100% on the same page. So bear with me. And for those of you that are intimately aware of all of the documentation and rules and regulations and policies, you can feel free to tune me out for a second. In my mind, this is the Charlie Brown teacher, though, the want. So 5 minutes, bear with me. We're having a lot of fun with memes and GIFs and references today. Very authentic experience going on. All right, anyway. So I will not go through all of the cases, but it is a consolidation of House, Hubbard, and Carter. There was a settlement agreement, obviously, May 23rd of last year. I've noticed some confusion when we talk about the word settlement and payment. So just for the sake of clarity, there are essentially 3 main categories. So you've got back damages specific to the student athletes opting in or out, as it were. You've got rule changes, and then future payments, which are specific to the institutions opting in or out. So for what that's worth, just making sure that we're keeping all of those things clear. Back damages, approximately $2.8 billion for Division I athletes participating from 2016 to 2024, obviously not counting broadcast NIL. We won't get to that today. in terms of rule changes, elimination of Division I scholarship limits in favor of roster limits for those that are opting in. Scholarship limits are now equivalencies. So up to the max roster limit, discretion to figure out what you want to do with your programs. Institutional involvement in NIL will be permissible, which we will get into later. And then, of course, enforcement and arbitration related to the settlement, details of which are still TBD at this moment. Next slide, please. All right, with respect to the pool, so the pool, 22% of average shared revenue based on a total of 8 categories. The estimated amount for 25-26 is about $20.5 million. For all intents and purposes, that is what we are calling the pool cap. We're talking about settlement payments, house payments. That is the amount that we're talking about. That amount will increase every year, and then in the second and third year before being recalculated, I would anticipate it continues to go up, but I'm gonna mind my business there. Things that are included in that pool cap: direct NIL payments between the institution and its student athletes, Alston payments, that famous 5980 academic award. I use the term award loosely. That will count up to $2.5 million. Additional scholarships beyond what is currently permitted, up to another $2.5 million. Again, just a note of clarification: you could offer more than $2.5 million actual dollars in additional scholarships and Alston payments, but for the purposes of calculating the pool cap, 2.5 counts respectively for each of those categories. All right, next slide, please. Third-party NIL agreements, including boosters, do not count towards the pool cap. However, fair market value assessments will apply to those third-party agreements with associated entities and associated individuals. For those that have been in athletics for a while, it's going to be probably really broad. What is an associated entity? What's an individual, associated individual? Where's the line? Where's the monitoring? All of those things, which I think a lot of us are very familiar with, will likely continue. The revenue share or the institutional NIL payments will count towards the pool cap, but are not subject to the fair market value standard. And for those that have constituents who are somehow under the impression that donors and collectives and boosters get to just run amok and freely operate and then total free-for-all, I do, as much as I am the sunshine and rainbow part of this team, I do want to rain on that parade just a tad. All right, we don't know exactly how fair market value will be assessed, how challenges will be managed. So for all of my folks on campus, please proceed with caution, consistent with whatever your personal institutional risk tolerance level is moving forward. A couple of other notes. Of course, I think we're all pretty clear on this one. All NIL agreements above $600 will need to be reported to the institution and a clearinghouse. Again, details, enforcement, monitoring, we'll see. Soapbox. Before I turn it over to Jason to talk about some remaining key questions, I do have just a personal takeaway from my campus folks. I love you. Institutional discretion, I think, is key in all of this. And I think there's a fairly small window of time to kind of unplug the whack-a-mole game, as it were, and determine how you want your institution to operate, inclusive of student athletes and coaches and administrators and supporters, all of those individuals within this fairly wide, large box of parameters, within this new model. And I think really importantly is what is going to be your basis for defensibility when, not if, whatever your decision is gets challenged. I think it's coming. I think we all kind of are on the same page that your decisions will be challenged officially, unofficially, formally, informally. It's coming. Prepare. It's going to be fine. So circling back to one of my favorite memes, yes, it's on fire. Yes, you will be fine. We're going to get through it. Jason, thoughts?
Well, one other point, it's a good reminder. Although institutional NIL is not subject to fair market value, I think practically institutions are going to want to demonstrate how they came to the conclusions as to what they're providing to athletes. And in part, that is likely going to be related to Title IX, which we'll discuss later. But in any event, this may be easier once there is a standardized reporting system to determine what everyone is paying for different athletes' NIL rights. And again, I think we can, with a straight face, say we're paying for NIL rights, but we're also paying for their athletics ability, which is inextricably intertwined with their NIL right. And we're moving more and more down the road of an inability to defend against an employment model.
So with that in mind, Jason, I know we have a key question, and Christina alluded to it, and I assume that you have other thoughts regarding the relationship between schools and their individual student athletes.
Well, I just think it's important for everyone to take a deep breath in Division I and pause, and I'll talk a little bit about what opting in and opting out means. Certainly, the Autonomy IV conferences have decided this is the path that is best for them to pursue based upon their legal challenges, and in order to create a structure that's sustainable, at least in their opinion, for 10 years. What I would caution is that that's right for every other Division I school, and the key question is ultimately, do you want to have an employer-employee relationship or a traditional student-athlete model, even if it's at Division I? Is this something that you want a professional model of college sports, or do you want closer to an amateur model? And is this only for football and men's basketball, or all sports you're sponsoring? I think all of these things need to be weighed institutionally, and there needs to be thoughtful conversation. I think right now we're in the midst of institutions and conferences that are not Autonomy IV, feeling as though that they need to automatically opt in order to not get left behind. And I guess my message to them is they're already left behind. It's the reality of the situation is the economic difference between those at the top 67 schools, let's say, versus everyone else is such that nothing is going to make up the difference. And so now the question really is about risk tolerance for your institution and what you want to do as an institution moving forward. So continuing on with the new Division I model, part of the reason that the NCAA convention concerned me and why it's concerning that there's a deadline for schools to opt in, which we'll talk about, is that it's unclear what NCAA rules will still exist and how they will be enforced. I think it's probably, we can speculate that the enforcement model is going to be outside of the NCAA, but we don't know what that is. There also remains in many states a conflict between the state laws and NCAA rules related to NIL, and also even the concept of the settlement agreement and state law. I think that most schools are proceeding with the understanding that those laws will be amended in some way to reflect a new reality in college sports, but that's not guaranteed. And I think that there needs to be some more thought given to what institutions want to do with respect to that before they start issuing contracts and so forth. Compliance with Title IX is unaddressed. We'll talk about how it was addressed just last week and how that may affect some decision making or at least risk analysis. But the reality is most institutions are intending to disproportionately provide house payments, which I'm using as a name for NIL direct payments to their athletes, disproportionately to football and men's basketball athletes versus everyone else, and certainly versus women's athletes. And the reason for that is pretty simple. It's those sports that the institutions feel drive the most revenue and result in the biggest impact for all of their sports. But the effect of that is yet to be determined, both the effect on women's athletics and whether it creates significant legal risks for institutions. There will now be a more substantive contractual business relationship with student athletes. I think there might have been an argument there always was a contractual relationship with respect to scholarships, but now we're talking about a business relationship and how that is implemented. We've already seen fissures in the short time that Toronto, I think we'll talk about later. But will there be any sort of enforcement in a court, Will that be left to arbitrators pursuant to the settlement agreement, or some mixed version of the two? Or will there be really no effective recourse for an institution that wants to continue to recruit similarly situated athletes? And then, the big issue is this just delaying an inevitable employer-employee relationship, either for 10 years or 5 years or a shorter amount of time? That may be the case. And without probably comprehensive legislative intervention, I think that's likely the outcome of this new Division I model. Okay, let's talk about deadlines. Well, in the latest entry into the ring of interest in college sports, January 31st is the deadline for objections to the settlement. Last Friday, the U.S. Department of Justice filed a statement of interest expressing concern that settlement may not cure the effects of illegal conduct. What they really said was specific to the cap, that was another artificial restraint that was inconsistent with the Sherman Act. I think that rightfully so, plaintiffs' attorneys reacted pretty strongly, asking the U.S. Department of Justice where they were. It's especially curious that this comes out right before the transition in administrations, but it is significant in something that they're asking the judge directly to address, which is a big tenet of this settlement. Some level of guarantee or protection from the autonomy for an NCAA on future antitrust claims, that the cap and opting in to this agreement by student athletes has some sort of protection. And what the DOJ is saying is it shouldn't. And if it doesn't, then what is the NCAA paying $2.8 billion for? I think what the concept here is that there needs to be some level of stability before there can be, a restructuring or reclassification. But if in fact that is the case, I think it's going to be difficult for there to be any sort of stability. Just the March 1st deadline for institutions to opt in or opt out. I had a spirited conversation with my colleague sitting next to me, Taronda, about what that really was. So the settlement itself says for all your other schools, you're not Autonomy 4 schools, you opt in if you provide benefits consistent with this settlement agreement. So above what you already currently provide, you automatically have opted into the settlement as an institution and as an institution as a whole, not on a sport-by-sport basis. The NCAA sent a Q&A out, I think it was the end of December, middle of December, that said there's a March 1st annual deadline for institutions to opt in or opt out. I don't know whether this is arbitrary and what the purpose of this is. I think people could speculate that we're trying to separate and see who is in and who is out, maybe. But I'm just hypothesizing that if you're an institution that doesn't opt in on March 1st, and then the settlement's actually passed. So first off, you might want to wait till the settlement's approved before you provide a deadline for opting in. Neither here nor there. I'm sure there's very smart people that are making these decisions. But let's just say in May, you as an institution say, well, now it's approved. You know what? It looks pretty good. We want to give one of our men's basketball players an NIL deal. I'm not sure there's anything that's going to prevent you from doing that, or any action the NCAA could take against you for doing so and not, registering on March 1st. So I think it's a little frustrating that there would be an arbitrary deadline set. And what it does is it creates a significant amount of pressure for institutions to coalesce around a outcome without having all of the information available to them. Again, final approval is on April 7th. If they made April 8th the deadline to opt in, maybe I'd feel better about it. July 1st is when this will be implemented. And again, it's a 10-year timeline. So, Tron, did you disagree with me on my position here?
I don't like us having our spirited debates during our actual presentation. And in the interest of time, because I am the keeper of time here, we have about 20 minutes left. And I know you have more than 20 minutes worth of content left.
No. So what does it mean for those folks that are deciding whether to opt in? So If you do opt in, you have the ability to enter into direct agreements with athletes and provide additional benefits up to a pool amount. You have the ability to make direct payments for NIL rights. That's the real recruiting issue here is, can you make direct payments, probably just to your men's basketball athletes and maybe women's basketball. If you do opt in, you have to adhere to the roster limits. That'll be different than the current limitations related to financial aid. And I would just say that those current limitations provide some weighting toward women's athletics, such that if you comply with the head count and so forth, you're more likely to be in compliance with Title IX. And ultimately, if you opt in, you're going to be governed by new rules yet to be established that are going to be adopted by the Autonomy IV conferences. And I think more importantly, and this, is not a lot of information out here about this, but what doesn't happen if you do not opt in? Okay, so you do not lose access to the NCAA championships. You're still a Division I member in good standing. You get access to the championship. Does not affect your current NCAA revenue distribution. That NCAA revenue distribution has not been addressed constitutionally as it would have to be in order to redistribute the money in a different way. You can opt in the future. Again, as I said, the settlement provides you can opt in at any point, but theoretically, according to some arbitrary rule, you could opt in again next March if you chose to. And I guess the real question is there any loss of competitiveness? And, did that really ever exist? Are you competing for, someone who wants hundreds of thousands of dollars to play at an institution? Maybe, maybe not. Maybe you want to be in that competitive arena, but that's an institutional decision. And so, those are really things that should be considered in the next month and talked about, by the leadership, both in athletics and at the institution. Okay, fun subject, Title IX. The question has always been how Title IX applied to NIL. And it was easier to suggest that Title IX is not applicable to third-party agreements. And then we've decided, or the Autonomy IV have decided, to directly pay athletes moving forward as part of the settlement agreement. So last week, the Office of Civil Rights came out with a guidance document, which, and I think is actually it's a fact sheet is the official title, that basically reminded institutions of their general requirements for Title IX, which included, providing support services and publicity equitably between men and women, but also stated that in their opinion, that financial assistance, that any money provided to athletes, including for direct payments for NIL, is considered financial assistance and need to be provided proportionally. Effectively meaning that if you pay your football players $10 million, you need to pay your women's athletes $10 million as well. This document, again, was issued 2 days before, or right before the change in administration. The fact sheet does not have the force and effect of law. I think we'll have to wait and see as to whether in the next 30 days this is rescinded. If it is rescinded by the new administration, it will have no effect. If it's not rescinded, then it will have the effect of if OCR intends to enforce the rule, this would be the manner in which they would likely proceed. There is some precedent about changes in administration and what happens in the Title IX space. So Bostic, which many of you would know, is a Title VII case that basically said Title VII protects employees from discrimination based on sexuality and gender identity. So it was a gender identity case. The Trump administration, prior to leaving, said that does not apply to Title IX. Biden administration came in and said, oh, nope, we're changing that. It does apply. So I think there is a likelihood in the next 30 days that something like that occurs with this particular guidance document, maybe, maybe not. If not, and then the risk is that there's going to be there could be enforcement actions by OCR related to this guidance if you're not proportionally providing your payments, NIL payments. However, this underlying document doesn't address specifically whether compensations for value should be treated differently than financial assistance. And I think that is the extent of my comments on this for now. But it is a significant document. I think it came about 3.5 years too late. But again, OCR has a wide berth of enforcement mechanisms and what they're attempting to navigate.
So Jason, I notice we have proportionally available underlined on the slide. Any thoughts as to what that looks like in practice?
I think the intent of this was that it's provided proportionally. I don't know what the language proportionally available. The regulation says proportionally, and this says that that essentially any sort of NIL payment is financial assistance that's the same as an athletic scholarship. So the regulation says proportionally. Proportionally available was a turn of phrase. I think some in the industry and some good attorneys have pointed out that's different. And does that mean something different? I don't think that was the intent, but we would have to ask OCR directly.
We would like to think that some people are here for our substance, but some may just be here for CLE credit. So with that in mind, Christina, I'm going to turn it over to you for the poll.
Yep, for those, most of you are still with us, so bravo. Just quick poll. I'm going to open it up now if it is not already open. Let's see if I can do this right. And does your institution plan to opt in and provide benefits consistent with the House settlement? Yes, no, I have absolutely no idea. We'll leave this open just for a few seconds. All right, I'm gonna give it like a 3-second countdown. I don't want to deprive anybody of precious CLE credits, but we do have some more content to go through. All right. Let's see if, hey, all right. There we go. All right. Most of you have no idea, and that's okay. We'll get there eventually. Moving on.
They'll know by March 1st, right, Jason?
In my opinion, they don't need to know by March 1st, but they can call me if they have questions.
April 8th, fine.
Okay, broken promises and legal woes. And Jason, you alluded to this earlier. This is just kind of the byproduct of where we are in terms of having contractual agreements with student athletes and expectations that student athletes have related to NIL. So we have Florida State men's basketball that came out a couple weeks ago. 6 former student athletes filed a lawsuit against the head men's basketball coach, and the complaint mentioned that the student athletes had actually boycotted practice last February because they did not receive the $250,000 that they were owed. The claims in that lawsuit include breach of contract, promissory estoppel, fraudulent misrepresentation, and fraudulent inducement, and negligent misrepresentation. And I think that, Jason, we can talk a little bit later about what institutions can do or think about as they have those agreements with student athletes to potentially mitigate the risk of some of these claims. There were some other lawsuits or similar issues that also made it into the headlines. So University of Florida football head coach and a staffer and a booster, they were sued. UNLV quarterback did not sue But he left the team after 3 games, I believe, due to a dispute regarding unfulfilled NIL promises of about $100,000. We also have recently former University of Wisconsin football student athlete that transferred to University of Miami without being entered into the portal, and Wisconsin alleged tampering, which is an issue in itself, and also noted the NIL arrangement that they would have with the student athlete. So Jason, any thoughts about broken promises, legal woes, what institutions can consider going forward in this new landscape?
Well, I think first and foremost, if you are going good down this path where you're going to enter into a contractual relationship, being clear on what clauses you have included and what the outcomes of those clauses are going to be is important. I think that having a strategy related to retention and related to what were to happen if there is an issue related to an athlete wanting to leave, and how you're going to manage that either through the contract or otherwise. I would say that I think probably the next rule that's going to be challenged is a tampering rule that restricts athletes from freely being able to communicate with other institutions about their marketability. I think that tampering generally is difficult to manage. And I think that if this continues to be a situation where that is an actual rule versus being addressed contractually or addressed through a settlement, that we'll see an antitrust challenge to that at some point.
So some remaining questions, and Christina, I know you have some background with that, so I'll kick it over to you.
As the new person, y'all give me the controversial slides just to wrap this one up. Much appreciated. That's what I get for not being in KC. All right, so we've gotten a fair amount of questions within our previous webinars in the comment box, then also in the surveys regarding addressing the topic of transgender student athlete participation. Yes, we actually read all of those comments and all of the survey responses. So you have been heard. From a purely factual standpoint, just giving a very brief overview, because I know we're low on time, of kind of where we are all at right now. Proposed Title IX regulations related to participation in athletics based on gender identity, as Jason mentioned earlier, were withdrawn. Federal court vacated the 2024 Title IX regulations on January 9th. I believe there is a white paper out there somewhere from Husch Blackwell on this issue. Anybody who's really interested in digging more into that. San Jose State volleyball. So several Mountain West women's volleyball teams forfeited competition against San Jose State University based upon concerns regarding the participation of a transgender student athlete. Lawsuit was filed by current and former Mountain West student athletes against the Mountain West Conference, Board of Trustees of Cal State University, and a number of individual staff at San Jose State. In addition to bringing up Title IX claims, a lawsuit also alleged conference's transgender participation policy violated the Equal Protection Clause under the 14th Amendment. Preliminary injunction to block this particular athlete's participation in the Mountain West Conference tournament was denied. One more, Texas Attorney General filed a lawsuit against the NCAA regarding transgender student athletes participating. This was from December 2024. The filing states, quote, the NCAA is engaging in false, deceptive, and misleading practices by advertising and selling goods and services associated with women's sporting events that are instead mixed-sex sporting events where men can compete against women, end quote. I am certainly not going to address the merits of that argument one way or the other, but the NCAA is following the rules of the NGBs, which obviously they don't always align. They're individual national governing bodies, excuse me. President Baker did state during convention that quote, the association would welcome federal guidance before it considers possible rule changes, end quote. So certainly more to come on that particular issue. Next slide, please. All right, and one more. I know we've talked a lot about student athlete employment and various cases and challenges. We actually might make time. All right, so Dartmouth men's basketball student athletes have since our last webinar have since dropped their push for unionization. College Basketball Players Association dropped unfair labor charges, including the charge against the University of Notre Dame. National College Players Association dropped unfair labor practice charges, against USC. And then from the Fair Labor Standards Act standpoint in the courts, there has been a third amended complaint filed in Johnson v. NCAA, and that was in November of 2024. We still have a split decision and lots to come there. What I will say in terms of the Third Circuit decision and Johnson v. NCAA, for those that need a quick reminder, Third Circuit ruled that athletes at NCAA Division I schools may be considered employees under the FLSA, but it has not been determined whether the student athletes in this case are in fact employees. So everybody continue to be tracking on that case. And as it relates to the NLRB cases, the student athletes have not, well, I guess personal opinion, we'll see, have not withdrawn or dropped their cases because they've all of a sudden changed their minds or don't feel that their cause is worth having. I think it's much more likely that this is a function of challenging a politicized issue. The Biden administration, the Democratic Party traditionally have been more pro-union. The Trump administration and the Republican Party are less likely to be so. So this appears more to be a strategic decision to pause rather than potentially risk losing and being stuck with an unfavorable decision. Either way, certainly more to come on this issue, as well as this and other questions and issues that we've talked about previously continue to evolve. So college athletics seems to be the soap opera that never ends. Here we are. That's all I have.
You know, Christina, you said that we might make time. That's before we turned it over to Jason and his crystal ball to talk about the future of the NCAA Division I and association as a whole.
Oh, I can vamp. Don't worry.
You have 3 minutes to do so.
No, so I don't think anyone has a clear idea of what the next phase is. But the framework, the first thing that we think we're going to see from the NCAA and probably Autonomy 4 is new rules. And again, I would start by eliminating the rule I discussed that could have probably been done 3 years ago or 4 years ago. But at least making some progress towards explaining which rules will be a part of the new Division I model and which rules won't. Does official visits, do those matter anymore when you're paying athletes? Is that still meaningful? Do the numbers of those matter? All of those things are
they can take as many as they would like now. So they did at least make that change. Let's give credit where credit is due.
Yes. You should. Yeah, you do give them a lot of credit. I think the other big piece here is that the reality here is that there is going to be more control by the Autonomy 4, and that may even mean a push for a greater share of revenue generated by the Division I men's basketball tournament. That could come in an expansion of the tournament. It could come in a change in how the distribution model exists. But ultimately, that group is taking on the biggest risk in the antitrust space for the amounts of money that are being paid out for these television contracts. And future legal challenges will continue until there is either comprehensive legislation at the federal level, which continues to be a possibility. Although anytime you're asking the federal government to solve your problems, it's probably you're in a bad state. And I just want to say before I conclude that with respect, we haven't forgotten Division II and Division III. Those that level of competition is going to continue to exist, and it could evolve based upon Division I members wanting to be D2 or D3 or change their model. There will be some trickle down effect from what occurs in Division I to come down to Division II and Division III, whether that be some level of NIL, whether that be some concept that athletes, have independent rights, that need to be articulated more directly, or whether it comes in eligibility. What we've seen consistently is what happens at Division I oftentimes then trickles down to Division II and Division III in some form. So with that, we're out of time. You're right. I could vamp for longer than that.
Well done. Right at 1 o'clock.
Appreciate everyone attending. I'll read our last spiel. We thank you. We hope the information was helpful for your school, and there'll be information related to the CLE opportunities available here, and we also include as supplements to this presentation the Title IX fact sheet that was published and the DOJ statement that was submitted to the court. So thank everyone for attending, and please let us know if we can be of any assistance. Thanks.